I'm not threatening you. Say one more word, and that's 30 days. 30 days.
Hey, what's going on, guys? Welcome back to Sovereign Citizens Hall of Fame. Today, I am bringing you number 93 on our compilation list. We will be in 3 different judges' courtrooms for this compilation. Before I give you the rundown on those judges, just know there will be no commentary added to this, and there also will be chapters added for your convenience. Also, don't forget to like, share, subscribe, comment, whatever blesses your heart. Long as it's positive, we just ask that you do so, and we thank you in advance. Now, the judges' courtrooms that we're going to be in on today. First, we're going to be in the courtroom of Judge Jeffrey Middleton out of the state of Michigan. Second, we will be in the courtroom of Judge Sean Perkins, also out of the state of Michigan. And last but not least, we will be in the courtroom of Judge Rachel Kraus out of the state of Georgia. Listen, this is definitely a classic, some of these moments that happen in these courtrooms. So let me get ready to get out of the way, and let's jump in to number 93.
I got an email from the White Pigeon Village attorney, Mr. Seth Coaches. He emails the court every Monday, pigeon cases, and it's very helpful. So let's talk about this. The charge, no valid operator's license, is a misdemeanor. It's punishable by up to 90 days in jail and a fine of up to $100. Carries 2 points on your driver's license and goes on your driving record. You're also charged with having an improper registration plate, which is a civil infraction that carries a $120 fine. Mr. Coaches emailed me yesterday, and he's willing to dismiss both of these charges for a plea to a less. That one is a kind of a strange charge. It carries no points. It doesn't go on your driving record, and it won't affect your ability to continue to work on getting your driver's license. Jail and a fine of up to $100. The normal fine is $100 plus costs. The other charges would be dismissed. The public defender, Mr. Keith Stickley, has joined us. He's available for any consultation for anyone if needed. But Mr. Coaches, the White Pigeon Village attorney, has agreed to save you $120 by dismissing the other ticket and 2 points and putting this on your driving record if you plead to allowing another to violate the motor vehicle code. Are you willing to plead to that lesser charge?
Can you a better definition of?
Sure. The charge you're charged with is not having a valid operator's license. That's a misdemeanor. It carries 2 points and it goes on your driving record. Let's take a look at your driving record.
Well, I'm practicing under the constitutional right to travel.
You don't have a valid license. And I heard you whisper to Mr. Stickley, you have a constitutional right to travel. That's true. You don't have a constitutional right to drive a car with no driver's license. So people come in with this they don't need a driver's license or a proper plate to drive. Well, in this state, you do. So the prosecutor has agreed to dismiss these. It won't go on your driving record, won't carry any points, and he's dismissing the plate violation, $200 anyway, and no points. So it's up to you. If you wish to plead guilty to the lesser charge, you can do that. Or if you wish to plead not guilty, I'll simply set the matter for a trial. What would you like to do, sir?
What's the second option you stated? The
Plead to
confusing one?
allowing another to violate the motor vehicle code. It's a legal fiction. You're allowing to violate the motor vehicle code is yourself, but the lawyers use it because it doesn't carry any points.
No problem.
It doesn't go on your driving record and won't affect your ability to get your license back if you wish to do that.
No problem.
So that's option 2. The other option is to plead not guilty and I'll set the matter for a trial.
I'll take the second option. The one you state that's confusing.
Okay, plea to allowing another to violate the motor vehicle code.
Yes.
All right. Where were you going?
I don't have a license.
All right, that's good enough. Now, you had a driver bring you today?
Yes.
Very good. Well, this will save you $120 off of that. What do you do, sir? What's your occupation?
Security.
Very good. You still live in White Pigeon?
Yes.
White Pigeon's a little town. If they see you driving, they'll pull you over again. Just a word of caution. There's no points. It won't show up on your driving record. The state costs are $125, so it's $225. But this won't appear on your record. Do you need some time to pay that?
Yeah. It could be Friday.
Oh, I'll give you more time than that. Can you pay it by October 5th?
Certainly.
Okay, that's $225, $10,523. We give you the rest of August and most of September. All right, sir, you're good to go. Priscilla, I'm gonna need your help. I've got at least one interpreter case.
Right. Just been advised.
Okay, and Frank's no help.
Mr. Lockhart,
Yes, hello?
are you, you've been here before, correct?
Yeah, I've been here before.
Have you made any kind of filings on your behalf?
Yeah, quite a few.
This is the city of Detroit versus Jamil Amir Lockhart. Appearance for the record, please.
Yeah, so I am Jamil of the family Lockhart. The motions that I filed and the documents that I have filed have all been trying to ascertain the jurisdiction of this court. And I don't understand the nature and cause of the action against me. And I'm trying to understand under what jurisdiction the court intends to proceed. First of all, is this going to be a civil or a criminal action? Criminal. Okay. Your Honor, the Constitution grants this court two criminal jurisdictions. One is criminal jurisdiction under the common law, and one is a criminal jurisdiction under admiralty or military tribunal. From Article 1, Section 8, Clause 17 of the Constitution. So in which of these two criminal jurisdictions does the court intend to try me?
Where is your motion, sir?
There's a motion filed there. It's a motion to dismiss based on lack of subject matter jurisdiction.
All right, I'm going to deny that motion. I'm going to set a bench trial or jury trial if you choose. Which one would you want to have?
Okay, Your Honor, under what grounds, what facts and findings and conclusions of law are you denying that motion to dismiss? I'm trying to understand the jurisdiction of the court. You have not disclosed it to me. I'm asking you
to disclose it to you. Check the court rules, sir.
Well, Your Honor, the Sixth Amendment grants me the right to understand the nature and cause of any action brought against me, and it grants you the duty to inform me. So I don't think you would be breaching your oath of office if you were to inform me under which jurisdiction this court intends to proceed. In order for me to intelligently defend myself without an attorney, I need to understand which jurisdiction the court intends to proceed to conduct
you have a very good attorney on the line, Mr. Elwood Terry. If you want to speak to him in a breakout room, I can give you that opportunity. Other than that, I'm going to set a bench trial or a jury trial in the matter.
Okay. Please let the record show that I have attempted to understand or to ask what is the jurisdiction of the court is operating under. And it appears that the court is operating under a secret jurisdiction, maybe only known to bar members and licensed attorneys. So let the record show that I am trying to understand jurisdiction and nature of cause against me, and the court has denied me that information.
I'm not denying you the information. The information is public information, sir. The information is outlined in the Michigan court rules. You need to read the Michigan court rules, and you can find out jurisdiction. It'll tell you everything about jurisdiction. That's entirely public information. You can go online and type in the court rules. The whole book is ascertainable to you online.
Sir, the Sixth Amendment grants
I'm not
you
required
to inform me of the nature and cause of any action brought against me. And right now, you are denying me that right.
I'm going to tell you, sir, don't speak over me. You want me to inform you of the nature and cause of the action. You're charged with driving, drive while license not valid or improper. The other charges, no insurance, misdemeanor. The allegation is that you were driving that same 2011 Jaguar in the city of Detroit without the proper registration on that vehicle.
I understand the
maximum possible. Don't interrupt me, sir.
Okay, go ahead. I'm sorry.
Those are the charges. Do you want a bench trial or a jury trial?
Your Honor, I am trying to understand the jurisdiction of this court. As I said, you told me it was a criminal jurisdiction.
If you read the Michigan court rules, the Michigan court rules will tell you and give you jurisdiction. So they have a copy of the Michigan court rules online or at the public library. I'm sure it is easily ascertainable, and we're not going to keep going down this road, young man. Do you want a bench trial?
So I cannot. I'm asking you a very specific question, and it is this a criminal jurisdiction under common law, or is it a criminal jurisdiction under military tribunal?
Listen, it's let's move on to the next person.
Sir, please answer that.
It
can only be one or the other.
You'll leave me no choice but to hold you in contempt. I'm asking you a specific question.
Your Honor, I do not wish to be held in contempt. I am trying to exercise my Sixth Amendment right. I can show you Constitution is exercise of a constitutional right cannot be converted into a crime, sir.
Sir, the way you speak to the court is via motion. Okay, if you have a motion that I've already denied one of your motions, if you have another motion.
Under what basis? Under what grounds have you denied my motions?
It's not my job to explain to you all of the court rules, sir.
Sir, there's only two jurisdictions which this court can operate under.
Just like any other, you're going to be treated just like any other lawyer that comes in this courtroom. So you have to know the rules.
Yeah, so I'm not trying to seek legal advice or ask you what the rules are. I'm asking you a very specific question. There can only be two jurisdictions under criminal law. And is it under common law or is it admiralty law?
On the record for Mr. Jamil Lockhart.
Yes.
All right. This is the last time I'm going to say this. I'm not going to continue to go back and forth with you regarding court rules and all of those positions that you have. If you put it in a motion, we'll set a motion hearing date.
If you are setting a motion hearing date, you are doing so without my understanding of the nature and cause of the action against me.
Listen,
and I cannot move forward until I have these questions answered. These are basic questions that you are obligated under the Sixth Amendment.
I'm not obligated to answer any of that stuff. I told you, I gave you the answer to that stuff by looking in the court rules. You're obligated to know the rules.
Sir, what you mentioned is statutory law. And if we are proceeding under some kind of statutory law, I motion that we dismiss for lack of a sworn complaint or anything signed by injured party. And in fact, where is the injured party? Is the officer present, and who is the injured party in this case?
The officer is not required to be present today. It is a pretrial date. I'll hold that dismissal motion in abeyance until the date of trial. If the date of trial, if there's no signed complaint on the date of trial, then we will dismiss by no signed complaint. So I'll give the city an opportunity to come up with a signed complaint.
I'm sorry, is the city the injured party here?
Yeah, you're here.
Okay, well, sir, I move that we either dismiss this case or move this case to federal court. If the city is the plaintiff or injured party, they cannot also be the judge and prosecutor.
File a motion on that, sir. If you're saying that I do have a signed complaint. Well,
that brings me back to my original question. Is this a statutory proceeding? Because if there is, there would have to be an international contract or agreement. And I would implore the prosecution to put that agreement on the record and explain how I am party to it.
Young man, you got to go do your homework, okay? And it appears that you're taking this position and you're adamant about this position, and you're free to do that. Now, whether you're going to win at this position, that's going to be up to what you say in your brief, and how it relates to the law, and we'll make a decision on that stuff, okay? But at this point, you need to educate yourself, because you seem like a very articulate, educated young man. You need to educate yourself on court rules and procedure. Until you get it correct, we can't talk, because we have to be speaking the same language, okay?
I mean, that's the main thing I'm trying to understand here, sir. Is this a common law criminal procedure
I'm giving you some direction on.
Well, sir, I don't know which rules. If you could tell me where I could find the rules for.
I told you, go to Michigan court rules. They got Michigan court rules.
They have rules for criminal procedure under statutory law.
Yes, very much so.
Could you please direct me to that?
I've already directed you to it. Michigan court rules. There's a book that's over 1,000 pages, and it'll answer, well, close to 1,000 pages. It has those questions outlined in there. You're expected to know
Are
that.
those Michigan court rules, is that statutory law?
I'm not going to keep going back and forth with you, sir. Whatever motions that you have, that's how you speak to the court, through motions. And whatever motions that you have, I will review it. I read all the motions that come across. I check all the law myself. And if you have some law, I would suggest that law that you're saying that we don't.
Your Honor, there is no international contract. I mean, we've asked the prosecutor to produce an international contract that would bind me to this statutory proceeding, and I'm not aware of any contract. In the absence of such contract, I motion that we dismiss this case. And for the record, I would just
in order to, you can move to the circuit court, and you can appeal my decision as it relates to that. But we're not going to keep on going back and forth.
I think we should move this case to federal court. As I stated, if the city is the injured party,
file a motion so I can, on your removal motion, file a motion.
I do not wish to continue or delay this any further. There's been no evidence presented to substantiate any kind of jurisdiction in this case. This is our second time. I've asked for this the first time, and there's been no evidence of any jurisdiction. And I don't understand why, you're insisting on, moving to another court date, and we have not addressed this very basic and fundamental issue of jurisdiction. If it cannot be proven and proven on the record, then this case must be dismissed. Well, I mean, I don't understand why we are delaying this any further.
We don't have to delay it any further. I can put a warrant out for your arrest, and you don't have to show up. I mean, you'll have to deal with that then. But at some point, you're going to have to deal.
Under what grounds, under what basis are you putting a warrant out for my arrest? And you
I didn't say I was going to put a warrant. I said if you're telling the court that you're not going to come back to any court dates, then that's up to you. All I can do.
What I'm saying, sir, is I don't wish to delay this any further. There has been no proof of jurisdiction. There is no live injured party. I mean, there's a claim that the city of Detroit is an injured party, but I'm not aware of any international agreements or contracts that I've entered into with the city of Detroit. And the prosecutor can't provide that. And it seems like there's a bias going on here because flat on his face, the prosecutor hasn't even spoken on this issue. And you just insist that we move to another court date. And I don't understand. I mean, your oath of office is to uphold the Constitution. And what I'm asking is
what you're saying in essence is that I don't have any authority.
I'm asking you to prove your authority.
I'm
asking you to prove your authority. I'm trying to understand where your authority is coming from. And you're failing to do so.
Read the Michigan court rules, read your statutes, read the Constitution over again, and you'll find that.
As I said before, I'm not asking you for legal advice or where
and the Michigan Constitution.
You have, if you have a legitimate jurisdiction, I'm asking you, is it a criminal jurisdiction under statutory law, or is it under the common law?
All right, we're gonna give them a trial.
And you will not answer that question. Your Honor, we cannot proceed until I understand the nature and cause of the action against me.
I'm gonna say this one last time to you, sir. Go, and if you want to speak to the court, if you have any objection to the court and these dates, and if you don't feel that these dates are lawful, and if you whatever your claim is that you're stating, you speak to the court through motions. I want that, and those motions that you're entertaining on the record right now, I've dismissed some of them already. I want you to file those motions with the court.
Under no basis
so that the court can read your motion and make a ruling and give the city attorney an opportunity to respond. If you do it the proper way, you might learn something. But I don't think that the way that you're going, that you're even if they show you documentation like it is in black and white, you're not going to believe that anyway. That's the perception that I'm getting from you. So I'm going to set these dates. It's going to be up to you whether you want to come to these court hearings or not. And if you don't come to the court hearings, the only recourse I have is to issue a warrant for failure to appear. Okay, so
sir, I still have this same question that you keep failing to answer, and without that question being understood,
and that's it. I'm done talking about it. Okay, that's it. So I'm going to set a
let the record show that the judge has refused.
Listen, sir, don't interrupt me again. Okay? Don't interrupt me again. Let's set a motion date for.
I do not consent.
Please do not say anything else, sir. Okay.
Sir, I'm exercising my Sixth Amendment right. The Sixth Amendment exercise of an amendment right cannot be converted into a crime, sir.
I'm holding you in contempt of court, sir.
As I stated before, I'm trying to understand the jurisdiction of the court.
I'm not going to deal with you. You're going to jail.
Pursuant to
let's pull out the contempt
the Sixth Amendment.
Whatever paperwork we need to do and fill it out, we're going to fill it out this time. I'm holding your client. Well, Mr. Berry, you are, I guess, not representing this client because this client is probably. Do you want the representation of a lawyer, sir, at this point now, sir? Because now you're looking at 30 days in the Wayne County Jail. Do you want the representation or not?
Please let the record show that I have attempted to understand the jurisdiction of this court, and this court has refused me that answer. And apparently it is a jurisdiction only understood to bar members and licensed attorneys. This is a direct violation of the Constitution, and I do not consent. I do not agree. That's it. Your Honor, I do not wish to be held in contempt.
It's too late.
I've merely asked a very basic, simple question, and you have refused to answer it. I feel as though the court is trying to constrain me to an unfair plea in absence of my understanding of the nature and cause of the action against me. So did you receive the documents that I sent you asking for your anti-bribery statement? Hello.
I'm going to order you to report to the Wayne County Jail today.
I do not accept. I do not understand the nature and cause of the action against me. You have told me this is a criminal jurisdiction.
Sir, please don't. I told you don't say. I'm going to ask some more days if you keep on talking. You already got 30 days.
Don't understand, sir.
I'm adding more if you keep on talking. Please do not say anything else.
I'm sorry, Your Honor. It happened very fast.
It's happening again right now on the record. So those are the reasons
I'm just
that I
apologizing.
find, again, another contempt. And it just continues to happen. And I'm going to, now, if you have one more interruption with me, sir, I'm going to add another 30 days to that. And you're looking at 60 days. You're going to get 30 days. Right now, you're going to get 60 days if you have one more interruption too. And it will be no early release. At this point, I'm going to order you to report to the Wayne County Jail. Sir, do you have any further questions?
I just want to make sure I can speak without being held in contempt or.
Yes, you may speak. I asked you, do you have any further questions, sir?
Thank you. Your Honor, I would just like to tell you, man to man, that it was not my intent to be in contempt. Has never been my goal. I try to do everything in accordance with the law. As you can see, I have filed documents. I filed motions. I've requested information from the court, all in a desperate effort to wrap my head around the proceedings and what's going on here today. And I'm sorry if I may have gotten frustrated and not being able to understand the nature and cause and action against me. But just again, that was not my intention. I look forward to handling this as amicably as possible. I think that the record will show, I think that the prosecutor will agree that there is no international contract to which I'm tied under statutory jurisdiction. And I would love to see it. I would love to see that evidence. But also, we covered the fact that the city is the injured party or the plaintiff. And this would be an improper venue anyway. But I appreciate your advice on handling that and moving forward with motions. I will be doing that. But again, this thing of contempt, it's just, as one man to another trying to understand and stand on my constitutional rights and exercising them. And I feel today, as what's happened is my pursuit in doing that has somehow been converted into crime against me, which is a tragedy in anyone's eyes, So I cannot consent to moving forward because I still do not understand the nature and cause against me. And I will be communicating in writing, and maybe, someone can give that to me in writing. And we can go from there.
All right. And the court has heard all of what I respect the fact that you're trying to use the system and you're trying to operate by your understanding of the system. And the court is not trying to impair you in any type of way to present any claims that you may have. I continually referred you to the Michigan court rules, the Michigan Constitution, the United States Constitution. You want to find jurisdiction, you want to challenge jurisdiction, and I told you, if you want to challenge that, you're free to do that. The court is never going to impair anybody to challenge any of the allegations that are held that are brought against them. But there is a procedure, and whether you want to, you got to play by the rules, sir. And whether you accept the rules or not, That's not going to change the rules and the stuff that has been codified and the stuff that has been litigated and argued for over 2 centuries. The rules are not going to change for your position. Now, I asked you to continue, not say anything. I tried. You know, I don't know what position you're really taking or where you're getting all this stuff from. And I asked you to put that stuff in motion. But when I asked you to please be quiet, please, I give you ample time to speak. I have not impaired your ability to put what's on the record, but you continually say the same thing over and over. And then when I ask you to please be quiet, and when I tell you that I'm going to hold you in contempt, if you're not quiet and you continually go over and over and disobey what the court is trying to say, then I have left with no other option to do what I've already done. So you have an absolute right to an attorney. I gave you Mr. Very, 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 very good attorney. Now, whether you want to listen to his advice or not, you have him there at your disposal. Other than that, sir, I don't know what to do for you.
Okay.
So I'm ordering
I
you,
think,
I'm
yeah,
ordering you to report to the Wayne County Jail by 5 p.m. today.
It just happened so fast, sir. I mean, I think we had.
Well,
and
maybe
there's
you
a
may learn
frustration
something
that
from
built
this.
up.
Maybe you may learn something from this, and that 30 days will give you an opportunity to go read and educate yourself on how this works. I got other people that are taking the same position as you, and I've afforded them the same exact opportunity as you have. And they did not do what you did today. They're holding fast on their position, and that's fine. I respect that. But I don't respect you interrupting me. And it seems that you really need an education on how this stuff works. And I'm going to give you one today. Now, Mr. Berry, can you put your appearance on the record, please?
Yes, Your Honor. Elwood S. Berry, Jr., P28880, on behalf of this defendant.
Now, do you want to speak with Mr. Berry in a breakout room, sir, or not?
No, with all due respect, Your Honor, yeah, I have the right to represent myself in my own person, and that is what I intend to do after having understood the nature and cause of the action against me.
Well, I've given you. We've gone over all the natures and causes. We've gone over the maximum possible penalty for these offenses. I gave you an opportunity to speak with how and explain to you how the court hears your representations. You can choose to file those representations or not. But in the meantime, I'm going to order you now. I gave you the dates. I'm going to order you now to report to the Wayne County Jail by 5 p.m. today to do those 30 days. All right.
I do not consent.
Ms. Ballard, what? I'm not going to call your case formally right now. Right now, what I'm looking for is how long do you think that it will take to present what you want to present to the court today?
To my understanding, has the court reviewed the affidavits that has been submitted?
Yes, ma'am, I have.
Okay. So what can I expect as far as procedure? How will this hearing go?
Well, so typically what will happen, because you are the movant, you're the person who's seeking relief. So I would call on you to make a presentation that you would want to make. Sometimes people choose to do that. Some people don't choose to do that. But the idea is that if you wanted to explain to me what your position is in some shorter or different way from how you put it in the filings that you made, and then I would call on Ms. Akpati on behalf of her client to make a response. And then typically, because you're the movant, I would let you have the last word. And then sometimes I rule during the hearing. Sometimes I take it under advisement. It just depends on the circumstances. But if you wanted to make a presentation to outline verbally for me what you believe are the important issues, how long would that take?
I'm not sure. To my understanding, with this hearing, I was under the understanding that the affidavits that have been presented are fully understood and that based on what I have submitted, that there would be a proper decision and ruling.
Okay, so I'm interpreting that, Ms. Ballard, as you wanting to rest on the materials that you've sent, and that's perfectly fine. Ms. Akpati, what presentation, if any, did you intend to make? I'm just trying to get a time idea of how long this might take.
5 minutes, Your Honor.
Okay.
From my position, I filed an affidavit of priority interest in the property. I don't understand how we can be at this point when I'm not a tenant and there's no contract for being a tenant. The other party, the opposing party, says that they have interest in the property, saying that they have a sheriff's deed, which is what it's a color of title. It's not the title. There's no position of equity with that sheriff's deed. So to my understanding, with there not being a contract, and I'm challenging the jurisdiction of this other entity, I'm requesting that this motion under the titles, under the Rule 60B, this is thrown out. It just, we don't have a contract. There's nothing to really argue here. So, it's clearly displayed and stated in the affidavit that I submitted, and bottom line, we don't have a contract. The other entity does not own this property.
Okay.
I have priority interest and equity in this property.
Okay. Thank you, Ms. Ballard. As I said, I have had a chance to review the magistrate court file and the appeal materials that you filed in this case. One question I did have, Ms. Ballard, is that part of the order that was entered against you, which you are challenging here, right? That the magistrate judges, the purpose of this action is because the magistrate judge entered an order that said that you were not entitled to possession, and that and you're challenging that order. And I understand that part. But part of the order also requires that for you to challenge it, you're required to make some payment into the registry of the court. And my looking at the system, I don't see that any payments have been made. I think that that's part of Ms. Akpati's argument in a brief that she filed a couple of days ago, that you have not made a payment into the registry of the court to preserve your appeal rights. Can you tell me about that? If you have made a payment and maybe I just don't have it in my system, or if you haven't made a payment, can you tell me the basis for that?
I have. They did not ask for rent. They didn't put an affidavit to ask for rent. So, and there's no contract. But I have paid into the court of registry. The paperwork is there.
Can you tell me how much you paid into the court registry?
All of it. It's on a continuous basis until this matter is resolved. The last month and the remaining balance, everything is in compliance with the order from Magistrate Judge Rachel.
Ms. Akpati?
Your Honor, just to get straight to the point, no payment has been made. I did call the court this morning, and there has been no payment made. So if Ms. Ballard is saying that she has made the payment, could she provide to the court some form of evidence showing that she's made the payment? Because again, as of 15 minutes ago, no payment has been made, or the court is not aware of any payment being made.
Yeah, I have looked in both the magistrate court file, which is often where those payments will go, and I've looked in this action. And the financial documents don't indicate that any payment has been made in either case, other than the original, I think, $103 filing fee that was paid by the defendant in the magistrate court. I don't see anything that indicates payment. I'm happy to follow up with the court because sometimes the clerk gets a little bit behind, but do you have any documentation regarding when you made those payments or the amount of the payment?
It was a couple weeks ago when I filed it into the court of registry.
Okay, what did you file? Did you file like a proof of payment, or what did you file?
It is basically a money order.
I apologize. I need to take a brief break for something. Hold on just one moment. Okay, Ms. Akpati and Ms. Ballard, I apologize for that brief interruption. Okay, so where we are right now procedurally is that there is a dispossessory order that was entered by Judge Brooks on December the 7th. Respectfully, Ms. Ballard, I don't, if you can provide me with some documentation of the payment, I'm happy to pursue that with the clerk of court and find out if there is some issue with it being credited to the wrong file or something like that. But absent any such documentation, there's no evidence that the required payment has been made.
So I tendered a payment into the court of registry. If my payment was not accepted, I would not have received a case number for this. Payment was accepted. It had to have been in order to get this case number.
Well, actually,
so I have to feel that.
Actually, that's not correct. So the file indicates, Ms. Ballard, the file indicates that you submitted an affidavit of poverty and that poverty affidavit was granted for the filing fee. So you didn't have to pay a filing fee to be able to open this case.
Respectfully, I tendered a payment in the magistrate court.
Right. I'm not questioning, Ms. Ballard, that you did. What I'm saying is I need some documentation of that payment because there's no such payment reflected in the magistrate court. And so if you have a receipt, if you have a copy of the money order, if you have even a bank transaction indicating where you withdrew that money from, or where you obtained the money order, that would be some information that I could then go to the clerk and say, hey, I've got a party telling me that they made a payment and there's no record of it. Can you help me find this payment and why there's no record of it?
According to law, I tendered the payment, and I don't know if there's some type of mix-up between both courts, but I filed it in both courts. The tender payment is there respectfully. Otherwise, I would not have been able. They even said this has to be satisfied in order to get a new case number for this appeal.
Ms. Ballard, I understand that. All I'm asking is, can you tell me what was the amount? When was the payment? Where did you get the money order from? That's the type of information that I would then be able to go to the clerk and confirm that information. And then they might be able to track the payment and figure out where it went if you made the payment.
All right. Can you hold one moment while I get the information? Thank you kindly. Yes. So let me just turn on my camera real quick. Okay. So
yes, ma'am.
I filed a notice of tender payment into the courts, and so to settle this account, I did file a tender payment to the courts, and I'm sure you can see the affidavit in there, and it has proper endorsement. It's been properly endorsed, and if you like, I mean,
Ms. Ballard, can you tell me the case number on that? Is it this case number 2023 CV 390-111, or is it the 23 ED 284322 case number?
It's 23 ED 284322.
Okay. Give me a moment to look in the file and see what I can locate. Okay. Give me just a second.
Thank you.
Okay. Thank you for your patience as I've sort of worked through this. Ms. Ballard, Ms. Akpati. I was able to locate the filing that that Ms. Ballard was referencing, which is a notice of tender of payment to settle and close account.
Yes.
And is that the thing you were referencing, Ms. Ballard?
Yes. Yes.
Okay, that was filed. It was filed in the magistrate court on December the 12th.
Yes, that is correct.
Okay. My review of the notice that you filed. So first of all, I've spoken with the clerk of court, and they have no record of any payment. They have looked everywhere they can think of, including associated with your name, associated with this case, associated with the Superior Court case, and they can find no record of payment. But more importantly, Ms. Ballard, my review of your filing seems to indicate that you are rejecting the acknowledgement that there is that money would be any like it doesn't appear that you actually submitted legal tender of any sort to pay or satisfy this. You instead submitted some sort of signed, some sort of authorized representative document, but no money order, no check, which I don't think they take, no cash, no certified check, anything like that. Is that an accurate statement? Am I correctly understanding what you filed, Ms. Ballard?
I filed a tender payment, and it didn't, I mean, the law says that I can tender a payment. It never stated how to pay it. So, I mean, I fulfilled the contract based on the order. I mean,
Ms. Akpati, other than the motion that you filed regarding the lack of payment and your statements here that there has not been a payment, what is your position on behalf of your client on this matter?
My position is that this matter should be dismissed. The Ms. Ballard has to comply with the order of the court before filing this appeal.
And so I have reviewed what you filed now that I understand what I was supposed to be looking at. And, due respect, ma'am, but it is not filing a paper that says I hereby tender payment that is not actually accompanied by a payment recognizable in legal acceptable tender in the United States. Then you have not made a payment under any legal definition that I am aware of. And so as a result of that,
what species?
Excuse me, Ms. Ballard, I'm speaking, and in a moment I'll let you respond.
So, I mean, on the order, it did not specify how to pay. What species of payment is on there to pay? It was not specific.
I'm sorry, are you saying it wasn't specific in amount or it wasn't specific in method?
In method, yes.
Okay. I disagree. This is a standard order, and the vast majority of everyone I've ever dealt with that deals with these orders understands that when it says tenant must, in capital letters, make the following payments into the court registry by the time specified, everyone understands that I've typically dealt with that means money that is recognizable as legal tender in the United States, which would either be cash or a money order or a certified check. And in the absence of those things being paid, then the court wouldn't have any choice but to dismiss the appeal. And so
I gave you a bill of exchange, which is the same thing.
I'm sorry, ma'am?
I gave you a bill of exchange, which is the same thing.
No, ma'am, it's not. A bill of exchange is not recognized as legal tender in the United States, and therefore it would not satisfy the requirement that tenant must make the following payment into the court registry.
Will you be so kind to confirm under what law?
For that reason, I am dismissing case number.
I mean, ma'am, I object. I object. I mean, it's there. Under what law does it say that it is not a legal payment, a legal tender?
So In all honesty,
Respectfully.
I don't know the answer. I could do some research and find the answer, but Ms. Ballard, it's your obligation as the movant to provide the information that the court requires in order to understand your case, to accept your case. And you have not provided me, more importantly, with any documentation or a legal citation that would provide me with some sort of basis to accept your providing me with this note of exchange as legal tender. As I said, my understanding of the law is that a note of exchange is not legal tender recognized in the United States, and therefore it does not constitute a payment.
You have not provided me an answer, but under what law?
Yes, ma'am, I did. The answer I gave you was that it was your obligation. Mr. Freehold, please mute Ms.
I need
Ballard
to finish what I have to say.
Mr. Freehold, please mute Ms. Ballard if she's going to continue to speak over me. Thank you. Ms. Ballard, you've been muted because you continue to speak over me, which is disrespectful to the court.
I'm not trying to be respectful. You're
Ms. Ballard,
me and not properly.
You are continuing to speak, and Ms. Ballard, stop. I understand that you do not like the outcome. I understand that you believe that that legal tender or notice of exchange that you gave me should count, but it does not. The answer to this question is that the order that was entered says that tenant must make the following payments into the court registry, and there were no payments made into the court registry, and the filing that you submitted does not constitute a payment of legal tender into the court registry and does not constitute compliance with the order that you make a payment into the court registry. And therefore, the case is going to be dismissed. Case number 2023 CV 390111 will be dismissed for lack of payment. Anything else that the parties need? Ms. Ballard, you may pursue whatever appellate rights you wish to pursue.
You cannot make a ruling over something that you don't know.
I'm sorry, Ms. Ballard.
You cannot make a ruling over something you can't know. You saying you don't know is an unacceptable response. Respectfully.
Ms. Ballard, as I said, my answer was, if you would like to direct me to case law that says that what you submitted is legal, Ms. Ballard.
I'm not threatening you. Say one more word and that's 30 days. 30 days.